Preserve, protect, and defend.
Preserve, protect, and defend.
The Constitution of the United States.
The Constitution of the United States.
So help you God.
So help me God.
Now, I congratulate you, sir.
So Chevron was decided in 1984, which was kind of midway into the Reagan administration. The Reagan administration came into office with a very strong focus on deregulation of the economy.
Reagan comes in, he's got a Democratic Senate, but he wins by a pretty healthy margin. This is one of his 4 platforms.
The incoming Reagan administration reversed some regulations that governed basically the application of air pollution requirements under the Clean Air Act to new plant and equipment being built in factories across the country. It was, we thought, a major step backwards in protecting people's health and air quality. And so we went to court.
But Chevron starts out as this puny little precedent and then grows to be a major landmark decision. And that's quite unusual. It's hard to think of too many parallels to that in jurisprudence.
It's absolutely the case that Justice Stevens did not intend for his opinion in the Chevron decision to create a landmark.
This debate about Chevron deference isn't academic. It has a real-world impact. Chevron deference empowers agencies to act, to play a lawmaking role, and it encourages courts to defer to federal agency actions. And it can have profound effects on our separation of powers, on the role between Congress, courts, and the President and the federal agencies that the President oversees, in ways I think the founders would have never imagined.
The Chevron Doctrine comes from Chevron USA versus Natural Resources Defense Council, which was a case from the 1984 involving an EPA regulation interpreting the Clean Air Act.
I would say that it was intended when decided by Justice Stevens, who was a liberal, to be discretionary, somewhat loose canon of construction, to deal with very close questions of administrative law where the precise understanding of a possibly ambiguous statute could produce 2 different outcomes. And the notion was the expert agency, which has dealt with the statute for decades maybe, deserves a little headway.
The court announced in the Chevron opinion what we now refer to as a 2-step standard.
The 2 steps of Chevron is, first, you ask whether the statute's ambiguous. It's applying the ordinary tools of statutory interpretation, the text, the canons, to figure out whether Congress had spoken clearly on the question. If they hadn't, then you move to step 2, the idea being that if Congress doesn't speak clearly, they intended for the agency to fill in the holes in the statute, not the court.
If the statute is ambiguous, then the court in Chevron said that reviewing courts ought to defer to the agency's reasonable interpretation of that statute, essentially recognizing that sometimes statutes are susceptible of more than one reasonable interpretation, and that choosing between those reasonable interpretations is a matter of policy choice, best left to the agency rather than to the courts.
If the case is decided at step 1, the agency wins about 40% of the time. If you get to step 2, if the court finds the statute ambiguous, the agency wins almost 95% of the time. And so if you're trying to figure out the impact of Chevron, of the deference itself, it is definitely true that once you get to step 2, the agency is going to almost always win.
This is the United States Supreme Court. It is the highest court in the land. In this decade, it will be called upon to make decisions about our environment, which may well change the face of the nation.
The growth of the economy in the 50s and the 60s had not been accompanied by any significant pollution control laws. The factory pollution, the car pollution was choking the cities and the suburbs where most people lived. The Clean Air Act passed with almost unanimous support, and it had very strong advocates in the Republican Party in 70 and 77 and even in 1990. And then we realized that industry, was getting more and more organized in lobbying the Congress and lobbying the administration, and we needed to have a presence in the administrative process and to go toe-to-toe with the agency's people and with the industry's people on technical matters as well as the legal matters.
In the Chevron case, the administration just basically wanted to win the case. They were interested in adopting the bubble concept. They thought it gave more flexibility to industry. So all the arguments in the case were really, is the bubble okay or is the bubble not okay? And no one was really talking about standards of review or how courts should review agency decisions in any systematic way.
The bubble concept was the phrase used by industry representatives and the Reagan administration to describe how they wanted to interpret the term stationary source as defined in the Clean Air Act. Environmentalists argued that the bubble concept was contrary to the plain meaning of stationary source found in the law. The CAA put strict limitations on emissions from stationary sources of air pollution, such as power plants or smelters, and defined a stationary source as any building, structure, facility, or installation which emits or may emit any air pollutant. The dispute arose from ambiguity over what constituted a source, whether it refers to each pollution-emitting apparatus within a plant or to the whole plant. The bubble concept referred to the whole plant definition. Imagine putting a bubble over an entire plant and only looking at changes in pollution levels coming out a hole in the top. This was favorable to industry representatives because it meant that as long as their net pollution was either lower or unchanged when they made modifications to or installed any new apparatus, they would not have to comply with any of the limitations for individual stationary sources.
The bubble first comes up in the D.C. Circuit in a case called ASARCO. The EPA, this was the Carter administration EPA, had been lobbied by various industries, including the smelter industry, of which ASARCO was part, to adopt the bubble policy because they wanted some more regulatory flexibility in how the new source provisions would apply to their industry.
Along comes the Reagan administration, and they changed the definition of a source in such a way as to exempt 90% of the stuff that used to be subject to these requirements. And we thought that didn't make any sense.
Paul Bator was in charge of overseeing the briefing and had to do the oral argument for the government in the Chevron case. David Doneger, a seasoned lawyer for the NRDC, argued on the other side. Bator approached the case was very much just to figure out how to win this case. The government was in favor of the bubble concept, and it was controversial. The NRDC hated the bubble concept. So that was the big focus on the case and the argument.
There were 7 justices in front of me. I went second. Paul Bator argued the case. And he argued in broad generalizations. We think the government's position is, basically throwing around the weight of the federal government.
There are some aspects of the Chevron opinion which were clearly sort of stimulated or framed by the Bator brief. Particularly, Bator made this argument in his brief that delegations from Congress to an agency can be both explicit and implicit. The main focus of the Bator brief was really federalism. The argument was that the bubble concept would just give the states flexibility to decide whether or not they wanted to use this approach or not, as opposed to mandating a federal approach one way or the other.
And when I got a chance to argue, I went back to the basics. The statute defines a source in these 4 terms. It's intending to capture the pollution in these 3 specific ways. When someone builds a new boiler or blast furnace, the effect of the regulation is to exempt 90% of all that activity from these pollution controls. How could Congress have intended to build this elaborate structure of requirements for a source, which are very specific, and then allow the government to redefine the underlying word to exempt almost all of that equipment from those rules.
The statute was kind of convoluted and very unclear, and the legislative history was also convoluted and unclear, and so Doniger had a tough time of arguing that the bubble was unlawful. The administration won the Chevron case unanimously by a vote of 6-0. When the case finally came to be decided, there were only 6 justices, which is a bare quorum. Justice White almost never got to assign a majority opinion because he was 4th in seniority. But the very afternoon after the conference, he sent a memo around assigning the case to Justice Stevens to write the majority opinion. This was a very unusual assignment. The notes in the Blackmun file indicate that nobody paid much attention to what Justice Stevens had written. But Justice White, I think, to again reinforce his decision to assign it to Justice Stevens, responded almost immediately with a strong, "I join your opinion," no comments about it. And then, interestingly, the other justices just fell in line very quickly, including Justice Brennan, who'd voted to affirm rather than reverse, and Chief Justice Berger, who'd voted tentatively at least to affirm rather than reverse. And so everybody kind of quickly joined the Stevens opinion. There's no evidence of any significant revisions. So I think in a way it was kind of like this case just went under the radar. When I asked about it, he always responded that this was just a restatement of the law. This was nothing new, and he was not trying to change anything in any significant way. But if you just focus on the beginning passage about the 2 steps and the suggestion that there are implied delegations to agencies to interpret statutes that sort of gives them this authority greater than the court's authority to interpret an ambiguous statute. And the concluding section where he talks about agencies are responsible to the president, who's answerable to the people through elections, and courts don't have any constituency, as he said. Those 2 sections of the opinion really were quite innovative, and I think were taken for all they're worth quite transformative. And so those 2 parts of the opinion are now what appears in the case books and what everybody thinks of as the Chevron Doctrine. But it was really, at the time, to the justices, it looked like just another case involving an agency issue, highly technical.
Some scholars call Chevron an accidental landmark because it wasn't something the court was anticipating to kind of do a sea change in administrative law. But the way he wrote the opinion was very formulaic, very rules-based. And the lower courts, in particular the D.C. Circuit, ran with that decision and created a much more sweeping principle of administrative law than I think Justice Stevens ever would have imagined would come out of that decision.
I think the D.C. Circuit loved it because it simplified the way he organized opinions about this. I think the government loved it because it simplified the way he briefed these cases. The Justice Department, of course, once it was given the gift of Chevron, sort of tried to use it for all it was worth. And that continued through the first Bush administration as well.
I can only speak for how we felt in the administration, which was, oh, good, they're making it clear they're not going to block Reagan's attempt to roll back certain aspects of the regulatory inheritance, so long as he does it right.
But then, of course, times change. You get the Clinton administration and so forth, and you get different administrations, and so whoever's in power sort of likes Chevron because it appears like it's going to do more to uphold their decisions than the old approach would. And who's out of power tends to be more skeptical of Chevron because they think the courts are probably going to be more likely to be where they win than before the agencies.
But agencies began to manufacture more and more sort of, I'm not sure you'd call them fake ambiguities, but certainly forced ambiguities, which they took advantage of to just dramatically extend their interpretive authority over just untold gobs of law covering the entire sweep of the American government.
It's not about the Chevron Doctrine. It's about the underlying policies. And in periods of time when Republicans have been in power, especially now, you see very determined wholesale efforts to roll back the law. And this is a neutral principle that we ought to be able to use no matter who's in charge. And the remedy, if Congress doesn't like outcomes, is to change laws, not to turn a blind eye when the president and his agency heads just violate them.
So the way I see it, there are two different layers to the current debate. One has to do with the ongoing and long-standing debate over how Chevron operates in terms of its two steps, and also under what circumstances Chevron ought to provide the evaluative standard. That's not a new debate. We've been having that debate for a long time. The justices aren't in agreement as to how you evaluate those questions, and we just continue on. The other part of the debate really isn't about Chevron deference at all. Rather, it's about deference to agencies altogether.
But the attacks on Chevron started during the second term of the Obama administration, like the real strong attacks. If I had to guess, part of it was there was a dissatisfaction with how much Chevron had grown. This was not Justice Stevens' Chevron anymore. It was a much more deferential, rule-based approach where agencies seldom lost.
We're comfortable constraining regressive administrations under the Chevron Doctrine. I wish that some of the Chevron hawks out there had been as comfortable living with constraining the actions of the Obama administration under the same tests.
If Congress does its job as the founders envisioned under the separation of powers doctrine, then 90% of the problems of Chevron go away because the ambiguities aren't there. And if there's an ambiguity, the courts are supposed to resolve the ambiguity, not the agency, and the courts are not supposed to bow to the agency.
The Clean Air Act has saved tens of thousands of lives per year, but through regulations that EPA had to issue. If they didn't have that assignment and they didn't have that leeway from the courts, it wouldn't happen. The skies would be a lot dirtier and tens of thousands of people would be dying every year who are not. Could be you and me.
If we decide to get rid of Chevron, just overrule it, what's going to replace Chevron? You know, are we going to go back to this multifactorial thing that seemed to create a lot of judicial discretion that Justice Scalia didn't like? Or what else would we substitute for Chevron? That's a very big question.
Sometimes debates over the nuances of Chevron's two steps or the scope of Chevron's domain can begin to resemble the debate over how many angels can fit on the head of a pin. It's easy to get lost in the arcana of those debates. We should never lose sight, though, of the overarching rationale behind Chevron, because that ought to be our touchstone in applying Chevron rather than the arcana of the nuances.